Law of Torts, Unit 1. In this unit, we'll be covering these 5 sections. Starting with, tortus denotes twisted, crooked in Latin. Everyone is expected to behave in a certain way, and when they don't do that, they have said to be committed a tort. Now, a wrongful twisted act, a civil wrong, either by the act itself or omission of an act, which causes damage to the plaintiff and results in legal remedies as award, unliquidated damages, injunctions against the defendant. Let's go word by word. Civil wrong. So all the torts are civil wrongs, but not all the civil wrongs are torts. For example, let's say there are 2 people, A and B. Now what happens is A doesn't take care of his own garden and there is a tree in his place. Now this tree has a big branch which falls on the pedestrian B as he's walking by. Now, just because A did not take good care of his own garden because of his omission of duty to take care, there has been an harm caused to the pedestrian B. This is the tort. Or even something like, let's say B was walking by on the road, just minding his own business, and all of a sudden A comes across and barks at him. Now that's not the right thing to do, right? So even that's a tort. Moving on. A wrongful twisted act, a civil wrong, either by the act itself or omission of an act which causes damage to the plaintiff. Here, since we're talking about it in the legal context, damage need not be just the physical or mental harm that has been caused to the plaintiff, but it also includes the harm to the person's legal rights. For example, let's say A has a nice house and a big backyard, a very long backyard, right? And B wants to go from point X to point Y. So instead of taking the actual route because it's very long, what B decides is that he's gonna trespass the land of A. Now, he does that. B trespasses the land of A and takes the shortcut. He goes from point X to Y, trespassing the land of A. Now, in this case, although he has not caused any harm to A, like he has not physically hurt him, but still, A has the right of his own property and his legal rights have been infringed. This is also a tort. It's a tort of trespass. Moving ahead. And results in legal remedies as awards, unliquidated damages, injunctions against defendant. If the defendant is found liable, then the court ensures that the plaintiff is provided with remedies. In most cases, it's unliquidated damages. Now, here unliquidated basically means it's not predefined. It depends on facts and may change from case to case. Injunction is when the court orders the defendant to refrain from doing something. For example, let's say that A has musical classes going on and what B does is that he's nicely seated in his house but he starts banging his plates. Now this is causing a nuisance to A. What court does is court orders an injunction against B to not do that, to refrain from doing the activity which is causing a nuisance to A. In all the examples we have seen so far, like let's say A is not supposed to bark at B and A is supposed to take good care of his own plants such that the branches don't grow and fall on the pedestrian, or something like B is not supposed to trespass the land of A to take a shortcut. Now these kind of things, they don't have to be written, like it's not possible for us to write down every possible scenario, right? And that's the reason law of torts is uncodified in nature. Definition of tort. For the academic purpose, we do have to remember a few definitions given out by the famous jurist. You can just take a screenshot of this thing and just a heads up, only use the double quotations if you're sure that you remember the sentence word by word. We keep saying Salmond. The full name is Sir John William Salmond. Interesting part is that he did his bachelor's and master's in arts first and then he got into law later in his life. And he was a judge, he was knighted, he was in the King's Council, and also the most important part for us is that he had authored a book on law of torts back in 1907. Moving to Winfield, Winfield's full name is Sir Percy Henry Winfield. He was an English law professor and also an author to the Principle of Law of Contracts 1927, which he had authored along with Salmond. The origin of law of torts. As of 2025, this concept of tort law exists in almost every legal system across the world. Common law countries like India, USA, and UK, we all share the same fundamental similarities when it comes to law of torts. And that brings us to the origin of torts. Origin of law of torts. The common law system and law of torts have said to have originated in the UK after the Norman conquest back in 1066. It's actually interesting to read on the Norman conquest, and by the way, if you're into Vikings and stuff, then yeah, I'm pretty sure to enjoy this too. Coming back to the topic, King William had centralized the legal system, and this was how the common law system started. They established the royal courts, judges were appointed by the crown. Over time, they started addressing the civil wrongs, and not just that, they were also recording the decisions and relying on them in case a similar situation arises in future. Over time, we got landmark cases that have defined and refined the law of torts. For example, we have Baseley vs. Clarkson of 16th century, I think it's 1681, and we also have Donaghy vs. Stevenson. Fast forward to today, India inherits the common law principles after the independence, and we continue to rely the English precedents while also adopting tort law to our local context. Difference between tort and a crime. Law of torts is based on precedents and principles derived from the judicial decisions. Also, tort is breach of duty against another individual or party which is recognized under the law of torts. Similarly, crime is recognized by criminal law. Bharatiya Nyaya Sanhita, which is codified in India, BNS. Simply put, crime, the criminal law, it is governed by the written statutes. Previous example where A was having his music classes going on and B was banging plates to cause a nuisance to A. Here, A cannot call criminal charges against B because something this petty, something of this low intensity comes under tort, not crime. Private civil wrong against an individual or a party. When someone is said to have committed a tort, something like nuisance, defamation, or even trespass, they have specifically caused an impact and harm to an individual or some specific party. But in case of crime, the act is considered as public wrong because it harms the interest of society, something like theft or murder. When it comes to tort, the parties involved do have the option to settle the dispute out of the court, and also the option to withdraw the case. But when it comes to criminal case, generally it's not compoundable, meaning it's non-settling due to the public interest. Unliquidated damages. We have briefly discussed this before. In torts, the remedy is to compensate the victim and also to prevent any further harm. In crimes, the goal is to punish the offender, mostly with imprisonment or even fine. Since tort is a private wrong, where only the specific party has been harmed, they are the ones who can file a suit against the other party. In this case, A is the one who is having a specifically problem nuisance from B, so here only A can file a case. And in crime, the state brings the action as the act is considered as a wrong against the society. We have this famous Nanavati versus State of Maharashtra case, if you know. Akshay Kumar's Rustom movie is based on that. The one who commits a tort is called as a tortfeasor, and the one who commits a crime is called a criminal or an offender. Tort versus breach of contract. Here, both of them are private wrong. The major difference is the tort occurs from breach of duties which are not undertaken by the parties but that are imposed on them by the law. And in contract, it's a breach of duty undertaken by the parties themselves. There is a contract between both the parties which clearly mentions on what would happen if any of the involved members are not to do their duty or something that is expected out of them. When it comes to tort, in few cases motive is necessary. For example, let's say that this time B did not wanted to trespass in the A's backyard. Like he did not want to take the shortcut, and he can prove that some of his friends had intentionally tossed him inside. If that's the case, then B can use this as a defense and escape the liability. In case of contract, intention is of no concern. No matter how good your intention is, did you do the job that you were required to do as per the contract? That's it. Okay. So harm has been done. What now? If it's a tort, the court gets to decide the remedy, and for the contract, it's already mentioned on how the settlement should take place in case there's a dispute. How's the contract? I find it much easier to understand this one by an example. Let's say that A owes money to B and C is A's father. Now, C wants to surprise his son, so he pays off the money to B. And A does not know that it's already been paid, so he pays the money to B again. Now, B chooses not to tell A that his debt has been paid off. In this case, B just enjoyed an unjust enrichment, and this is where quasi contract comes into play. Quasi contract acts as a remedy for dispute between two parties that don't have a contract. It's a legal obligation that B has to pay back C the money he had accepted earlier. Law of tort versus law of torts. There's this nice article I found on the internet that explains this very well. I'll share the link. So, is it law of tort or law of torts? Well, all the academic books that I know of says it's law of torts, like R.K. Bangya, Pillai. Yeah, that's it. The reason that we're even having a discussion on this is because it's not about the singular or plural form of the word tort, but because there are two different approaches, theories for this subject. When we say law of tort, we're talking about the theory which Winfield supports. According to this, all the wrongful acts done against a person shall come under tort unless there is a legal justification for it. In case of law of torts, Salmon states his pigeonhole theory. Essentially, what's happening is that, let's say, there's a few sets of predefined torts: defamation, nuisance, negligence, trespass. What's happening here is that if the wrong that has been committed, if it falls under any of these predetermined torts, only then there's a liability for it. If there's a wrong that doesn't fit any of these boxes, if someone comes up with something new kind of wrong, then that's not a tort. Essential elements of tort. As we have seen in the previous example where A barks at B, or A does not take care of his own tree because of which the branch falls on the pedestrian B. For anything to be a tort, there has to be an act or an omission of an act on the defendant part which leads to the injury to the plaintiff. Here, even if there is no physical contact or mental harm but legal rights of a person has been violated, then that comes under the injury. The act or omission of the act has to be voluntary. As per the famous jurists as Austin, Holmes and Stephen, a voluntary act is an act that is controlled by a person's consciousness or will, and it is often regulated by the brain. That being said, even if the act was voluntary, it is considered wrongful only on the consideration on the grounds of consequences it produces and the circumstances it has been performed under. Let's go back to the example where B had trespassed the backyard of A. Here, this time, let's say that the B jumped into the A's backyard because there was a really mean dog chasing after B. And in that very moment, B couldn't find any other way to save himself than to jump in the backyard. And even if he did jump, he did not break anything away. A was nicely seated in his house. Of course, there are exceptions and defenses. As we need to consider, we need to understand that not every day is the same and there can always be something unforeseen, unavoidable, that should be taken into the consideration. In one of our very first example where we said that B trespassed the land of A just to take a shortcut, it was B's willful, voluntary decision to trespass the land to take a shortcut. But if we are to say that his friends have tossed him inside, that's something involuntary on the part of B, right? Here B is not liable, but his friends are. By the way, the one who files a suit starts a legal action. In the context of civil matters, he is the one whom we call petitioner. And the other party against whom it's being done, that's the one who is called as a defendant. Now let's say कि the defendant loses the case, the petitioner wins, and defendant is not happy with the decision of the court. What defendant can do is he can approach the higher court with their appeal, and then in that case, what happens is defendant becomes appellant and the petitioner becomes respondent. Malice, intention, motive, recklessness, they all sound similar, right? That's the thing. They are similar but not the same. That's the reason we are even having to study all this. In general, for someone who's not from law, malice means having an ill will, having those negative feeling towards the other. Malice, in fact, is nothing but the evil motive that one has for the wrongful act that they commit. On the other hand, malice in law refers to the act that are done without any just cause, any excuse. It need not be evil, which means that the trespass wala act, where B trespassed the land of A to take a shortcut. That's malice in law. There was nothing evil in it, but it was a wrongful act without any just excuse. One cannot just trespass the land of other person because they wanted a shortcut. That's a private property, right? I mean, you cannot justify the act that you wanted a shortcut and that's the reason you just stepped into the other person's property. The reason that we will have to study about malice in fact and malice in law is because there are few torts like apna, malicious prosecution, where malice in fact has to be proved in order for the defendant to be held liable. For us to have clarity on what we want to do, it's also good to know what we don't have to do. When it comes to law of tort, intention is irrelevant in few cases. Like, let's say here, B cannot just say, like, oh, I had no intention of harming the legal rights of A. I just wanted a shortcut. I did not mean any harm. Intention is irrelevant when it comes to trespass. But let's say that we were to talk about assault. Now, here, B is a big 6-foot man with a sane mind, and he's walking in aggression in a threatening manner towards A with a gun pointed towards A. Here we can reasonably say that there is an intention, and one of the essential for tort of assault has been met. For the intention, there is this landmark case of Wilkinson versus Downton of 1987, where Downton had made a joke to Miss Wilkinson that her husband had an accident in which both his legs were broken. Now, these statements were false, and as a reckless joke, Downton intended them to be believed as true by Miss Wilkinson, and sadly, she suffered a shock to her nervous system. Later, she claimed compensation for her illness and suffering following the false representation made by defendant Downton. Here, Downton claims that his intentions were to joke, but his actions led to the infringement of the Miss Wilkinson's right to personal safety, and the court said that this was something remote and foreseeable. Hence, his intention to jokes are irrelevant and he's liable to pay the damages to Miss Wilkinson. Moving on to motive. Motive is a person's state of mind that inspires them to do an act. It means the ulterior reason that they have for their conduct. How is this different from intention? Intention is something that can be apprehended by the act that is being done. Motive cannot. In our previous example, where we said that B is aggressively walking towards A with guns out, just by witnessing the act, we can reasonably say that B has an intent. But okay, let's get a bit dramatic here and let's say, who knows? Maybe someone kidnapped B's daughter and they asked him to do the act of threatening to A. Here, B's motive is to keep his daughter safe, but his intentions are clearly to assault A. One thing that we have to remember is that a wrongful act does not become lawful because the motive is good. Similarly, a lawful act does not become unlawful because of the bad motive. Which brings us to the landmark case of Bradford Corporations versus Pickles, 1895. In this case, defendant Pickles, he wanted the plaintiff to buy his land at higher price. So what he did was he had some excavations in his own land done such that the underground water would draw away and not reach to the reservoir of the plaintiff. Because of this loss, the plaintiff wanted to restrain defendant from doing his act. The plaintiff's appeal was denied because Pickles was making lawful use of his land. Moving to malfeasance, misfeasance and nonfeasance. Malfeasance is when the act itself is unlawful. One does not have to prove intention, malice, or even motive. The fact that the act has been committed, that makes it actionable per se, which means that something unlawful, illegal has been done by the defendant that has caused an injury to the plaintiff. Now, this injury could be physical, mental, or even just to the legal rights. And here, in this case, the defendant is held liable to compensate the plaintiff. For example, trespass. If B is to trespass the land of A, then A can have B held liable and seek legal remedies for this. Moving on to misfeasance, improper performance of a lawful act that results in harm to the other party. Let's say in a nice 5 star, there is a janitor who is mopping the floor and he leaves it wet without any signboard, any caution that the floor is wet. And our friend B, he walks onto the floor like he's in rush to reach the toilet, and on his way he falls because the floor is wet. Here, janitor or his employer, they can be held liable on the grounds of misfeasance. Non-feasance is when one party, let's say A, has a duty towards B, and omission of that duty causes an harm to the other party B. For example, let's say this timer A is a lifeguard and he's on duty. B is a kid who's drowning. He calls for help, like he's in water, he calls for help. But A is nicely sleeping, like he's asleep. And here, there is a clear omission of duty on the A's part, and this is an example of non-feasance. For the same example, let's say C, a stranger, is also present at the premise, but he chooses not to save the drowning kid B. For whatever reason, maybe he's afraid, who knows. We cannot say that there is a non-feasance on the part of C as well, because C has no legal duty of care or even any obligation towards that kid. Like he's not a lifeguard, right? He's not the one who's employed. So if C is to not save the kid, is it wrong? Maybe. But is it unlawful? No. Damnum sine injuria. This refers to a situation where someone, a party, they suffer harm or loss, but there is no legal remedy. They cannot claim damages because the harm was not caused by an unlawful act. There has been damages to one party, but none of the legal rights were violated. It's easier to understand this by using cases. We have this landmark Gloucester Grammar School case all the way back from the 14th century. From what I understand is that the defendant here was a teacher at the plaintiff's school, and he quit his job and started his own school in the nearby area. And for this reason, the plaintiff, Gloucester School, they sued the defendant for monetary compensation as they were losing students and revenue. Although there was a financial harm, a damage to the plaintiff, but there was no injury of legal rights. They both have the freedom for a fair competition, and the court decided to not take an action on the defendant. Once again, let me remind you that this is a case from the 14th century. Pretty sure that something like this won't happen in these times because now we have all the contracts that employer has to sign and accept if he wants the job. The contract could have a section on something like it clearly mentions that he cannot start his own school or even join a competing school for at least 6 months after resigning or something like that. Moving on to the case of Mogul Steamship Company versus McGregor Go and Co. 1889. From what I understand, here the defendants, they had formed a group, an association, such that they get to regulate the prices. And that's what they did. They all collectively lowered the freight charges to drive over the competition. Now the plaintiff sued the defendant for unfair competition, and the court held that the defendants were not liable simply because their objective was to merely protect and extend the trade, and also they had not used any unlawful means. They did not do anything that was dishonest or even to intimidate the plaintiff. Injuria sine damnum. Now this is the other way around. Injury without damage. There are cases where it is possible that there has been no financial, mental, or even physical harm or loss of any kind to the party, but the legal rights have been infringed. And when that's the case, they can have the defendant liable and seek legal remedies for it. This maxim comes in handy when the act committed are actionable per se. For example, the trespass wala thing. Here, although there was no damage to B, like there was no harm to B, but his legal rights have been infringed because B wanted to take a shortcut. And this is actionable per se. In case of Ashby versus White, 1703, the plaintiff, Ashby, was a qualified voter in a place called as Aylesbury. What happened was that he was prevented from voting in the parliamentary elections by the defendant, White, who was an officer back then. So what happened next is that Ashby sued White for the damages because his legal right to vote has been violated. And the court agreed to that. They ruled in favor of Ashby. And with that, the Unit 1 comes to an end.